Asanati Lole-Taylor.
Tāle whalawa, Mr. Speaker.
Mai oi.
Manuia whawhetai.
Whawhetai lava.
Kia ora and warm greetings. I myself would also like to acknowledge the Minister and the efforts that she made to talk to us about this bill. This morning I received a message, Mr. Speaker, from one of our community members, and I'm saying ours because you and I come from the same electorate. And the message goes, the problem here, I hear somebody trying to be smart on this side, and I'm sure he can't remember or understand a single word he's saying. The message goes, the problem here in this country is that the law has given younger people more authority, which leaves parents hopeless and can do so little to discipline their kids. Now they can commit more crimes knowing they can get away with it. What will the government do? Allow more laws for rehabilitating the criminals and nothing for the victims? And then there are 12 question marks and then the word sucks at the end. Mr. Speaker, these words represent frustration and anger, and it is not the fault of the person who sent it, but this House. This House is responsible for the words of frustration and anger. It was 2009 when the Parole Extension Supervision Orders Amendment Act was passed through a rather rushed process from its introduction to its third reading. Now, it's interesting because New Zealand First was not here at the time. There was no formal debate during its second and third readings because leave was given for the bill to be introduced and read on the same day. New Zealand First was not part of the process during that time, and what a shame, what a shame. If that bill had been debated in a considered manner, then members of Parliament during that time may have considered whether the bill was not just about fixing a technical error. We are here today debating the matter because of those who sat in this chamber in 2009 and did not carefully scrutinise the bill. We are here today to fix up legislation which fails to protect victims of sexual assault and fails to protect the most vulnerable of our society, our children. The Band-Aid approach of a 10-year limit was not enough. It was not enough. The first extended supervision orders handed down in 2005 are due to run out or expire early next year, meaning the Department of Corrections will lose its ability to manage those child sex offenders in the community. I am glad the Minister of Corrections has decided to address the issue of protection for our communities. I am also glad the Minister has accepted the need to address the issue of protection for the public against these high-risk sex offenders. We need to ask why it has taken recent cases of serious reoffending to finally decide that it's time to do something about it. We all remember Stuart Wilson, and it is a public case out there, released in September 2012, back in jail in April 2013, 20 years for sexual and violent offending. Sentence expires December the 1st next year. So we're talking about $27,000 at cost for this area to be fixed per person per year. And the time has come for it to be addressed. The ostrich mentality of locking them up and throwing away the key, as we all know, does not work for such offenders. The Corrections Department needs to redirect its attention to serious rehabilitation programs. They must put protection plans in place so that victims can be confident that they are protected. And we're talking about victims. They need to be assured that they are safe to live free of fear, that offenders under supervised orders will not re-offend after serving their 10-year parole period. This This legislation will expand extended supervision orders for child sex offenders beyond their current 10-year time frame. Well, this is for those who pose a high risk of serious offending. It will also expand their use to include high-risk sex offenders against adults and very high-risk violent offenders. Managing those high-risk sex offenders and very high-risk violent offenders is imperative for the safety of our communities. There is no room for error. This bill must ensure that, given the threat of serious harm posed by offenders, the rights of New Zealanders to be free from sexual harm and violence is upheld. The bill provides the courts to order the imposition of special conditions, allowing intensive monitoring of offenders for first 12 months of the extended supervision orders. The intention of this bill are in line with a similar bill introduced by New Zealand First to amend the Sentencing Act. In fact, the two bills work hand in hand. Both bills are focused on protecting victims. Where the extended supervision orders bill maintains the safety of victims after offenders have been released, New Zealand First Sentencing Protection of Children from Criminal Offending Amendment Bill acts as an additional deterrent for potential re-offenders post-release. Our bill makes potential re-offenders think twice about re-entering a life of crime after they have served their time. Children and minors are involved in a significant proportion of total crimes, and our bill is about keeping them safe. Would-be offenders cannot escape the fact that the criminal activity and criminal behaviour almost always has an impact on children at some point, whether it is in the home or on the street. Both bills are especially relevant for combating paedophilia, child abuse, and other such crimes where victims require ongoing protections. Both bills acknowledge that victims suffer long-term mental, physical, and psychological effects from the crimes committed against them, which means that the law should support victims as much as possible. Both bills are not just about preventing criminals from re-offending. They are also about protecting the rights of victims and potential victims to live fair and free lives. It is also about protecting our communities. It is crucial that the communities are at the core of our role when introducing legislations that are meant to address criminal activities. This extended supervision orders and our bill go hand in hand. Supporting our bill would double the effectiveness of this extended supervision orders bill. This is an opportunity for the government. This is an opportunity for the government to do some serious consideration for the New Zealand First bill. Mr. Speaker, it is important that the correct measures are put in place to not only protect their victims, but to allow reintegration into communities at a safe and monitored level. Parliament must have the ability to change in order to validate the measure of intelligence. And intelligence is what we need right now for the sake of our community and our country. New Zealand First supports this bill at its first reading. Thank you, Mr. Speaker.
Whawhatai lava. I call the honourable member Mike Sabin. Tēnā koe, Mr. Sabin.
Kia ora, Mr.
And
Speaker.
can I, sorry, before I call him, I just want to advise the House that we have a split call. Thank you.
Absolutely. Thank you, sir. Pleased to take a call in support of this